To give you a sense of ADR first, is that ADR we should understand as appropriate dispute resolution. When we are looking at ADR, we need to see what is the type of dispute and then see what would be the appropriate mechanism for it. Like, to give a ready example, we all know that arbitration is not possible for matters of landlord-tenant cases in the small causes court, at least in Bombay. However, mediation can be used here, implemented here, for getting a settlement between the landlord and tenant, for the simple reason that mediation is nothing but facilitated negotiation. And if the landlord tenant can negotiate their dispute amongst themselves, there is no reason why they cannot be facilitated into that conversation, and therefore mediation would be the right way forward even in those sort of cases where the statute itself bars even the High Court from taking up these disputes. Now, we have got several options in ADR mechanisms. Some of them are available in India, like negotiation, conciliation, mediation, and judicial settlement, what we know as Lok Adalat in India. The others will soon be coming to the shores of India down the line. And till then, we have to make do with negotiation, conciliation, and mediation for the time being. ODR is not just taking ADR online. It is not just mediating online. Our ODR platforms sometimes add a lot of value to the way you do your mediation. And yes, you can certainly replicate what you are doing offline by taking it online through video conferencing. However, if you have some sophisticated platforms for addressing disputes, then you could very well get much more value for the parties who are in that ODR platform room before you. Now, really, when you look at it, the phobia for anything is usually in equal proportion to the ignorance thereof, which gets then accentuated by the benefits in the other options that are available before you. Even we lawyers feel that the benefit in the other options is that if I take the dispute through litigation, then my billable hours increase phenomenally. Against that, mediation gives you just a few hours, maybe 20, 30 hours. And in that too, the lawyer's role is hardly 5-7 hours, maybe 10 hours. For assisting parties, he may still prefer to be there, especially in commercial matters. The lawyers are always required to assist the parties. But otherwise, for other matters, they may not be required, and therefore their billable hours go down drastically. So lawyers do have buy-in for some other processes which are a little elongated, and that's something which happens always in all jurisdictions in the initial stages. Once things get rolling, then there are so many matters moving in that a good lawyer is always sought after for getting redressal quicker than someone who is going to take you through the litigation path. And as far as the billable hours are concerned, that's something which again gets replicated with getting more matters of a few hours in mediation. And I'll tell you one thing, that parties always really benefit and therefore are really enamored and very grateful to such lawyers who get them resolution in a more humane manner and in an efficacious manner and with much less pain. Talking of pain, I am a regular at the doorstep of the dentist. So I take an example from that field. That person went to the doctor and showed him his tooth, and doctor said, yeah, I'll have to do a little bit of removal of your tooth because even root canal is not possible. It's just gone. The doctor was asked that how much would it cost? He said, well, about $50 and maybe a little bit, $1 or $2 for some medication if required. But otherwise $50 will be my fees. And how long will that take? The patient asked, and the doctor said, well, just a couple of minutes. He said, what? $50 for a couple of minutes? So the doctor said, well, I could do it a bit slowly. And that's what we lawyers do. We do get resolutions, but we do it slowly so that we get to justify our fees. And in the process, the party suffers. Mind well, I do not at all denigrate the legal profession. I may tell you that I have been born and brought up on legal fees. My dad was a lawyer. And even presently in my family, I have about 10, 12 people in my immediate near family who are all lawyers. So nothing against law or lawyers, but we need to understand that we as lawyers are there for the parties, and therefore we must get for them something efficacious. Now looking at the options in ODR. In ODR, to sum up quickly, we have several ways in which we can take the parties through the ODR path, all depending upon the level of their sophistication, as also their connectivity, as also the training of the mediator himself or herself. First thing we are doing is using text and using the mobile phone. So text and audio is of course there. Nowadays we are using audiovisual platforms like this present one, Zoom. So we are also used to audiovisual. And then we have a combination of these three. So if you notice that there is nothing great about ODR as such. In fact, if you notice, we have been using online platforms, online means, connectivities for all our back office work. Now we just need to bring our front office work online. And the basic difference between several of these platforms is the last two words, that either they can be synchronous or they can be asynchronous. And of course, there are some nuances there too. Like, for example, presently we are synchronous, but it's presently a slightly one-way traffic that we are having. Especially in areas where bandwidth is an issue, maybe you want to prefer one-way mode or a text mode, which would be less stressful for the connectivity that you have. Now, here we start off with our platform for ODR. This is one of the half a dozen that we are glad to be having in India, our own homegrown production. So should make the PM and his cabinet very happy that we are doing made in India, make in India, use in India, by Indian, for Indian, of Indians, everything just about Indian. So here we go with the demonstration. It's about 5 minutes, 6.5 minutes.
Welcome to this demo on CREK platform. CREK is an online dispute resolution platform that comes equipped with all the necessary tools that are required to resolve disputes online. In this demo, we will see the ADR flow that covers the major stages of dispute resolution, that is intake, negotiation, mediation, and arbitration, with the case manager managing the flow, and assignment of neutrals. The case manager files the case on behalf of the parties. The case manager enters the case description and party details. If there is a legal representative representing the parties, the case manager enters the party representative details. Once the case manager clicks the submit button, the case is created and the parties are notified via email with a link to set their password and a link to access the dispute. The parties then click on the link and come on to CREK. The parties will have to agree to the mediation arbitration agreement to proceed further. Once the parties agree, a support discussion is created where the parties can reach out to the case manager for any clarifications throughout the dispute life cycle. The case manager now moves the case to negotiation. A negotiation session is created with an SLA time by which the parties should arrive at a resolution. In case one of the parties is not willing to negotiate and wishes to proceed to mediation, the party can request to move the case to mediation. The case manager can move the case to mediation when the SLA time for negotiation is crossed, or if either of the parties has requested to start mediation. While moving the case to mediation, the case manager assigns a mediator. The mediator gets notified about the case assignment with the link to access the case. The mediator can access the case by clicking on the provided link. Mediator has the option to prepare for mediation by requesting any required information from the parties. The mediator uses the options questions to Susie and questions to Larry to ask for any required information. The mediator can also request for documents that might be required from the parties. The parties will receive an email that the mediator has requested for details. The parties can then respond to the mediator by clicking on the Respond to Mediator option under your next steps. Party can also submit the documents by clicking on Submit Documents option. In case one of the parties has not responded to the mediator, then the mediator can remind the party using the Remind Parties option. This enables the mediator to keep all the communication within the CREK platform. After receiving all the required information, the mediator can click on Start Mediation under your next steps to start the mediation process. This will create the joint caucus and private caucus where the mediator can conduct online mediation. There is an option provided in both the joint caucus and private caucus to pause the session. This can be used by the mediator to moderate the session by pausing the session when the mediator is not available online, or when one of the parties gets aggressive that may impede the mediation process. The mediator initiates private and joint discussions, and parties and mediator can exchange messages back and forth. One thing to note is, this is asynchronous communication, as in, all the participants are not required to be online. The parties who are offline are notified on every new message via email so that they can come onto CREK to respond to the messages. In case the mediator chooses to schedule a video call, the mediator can use the CREK calendar to schedule a new session. The scheduled session can be telephonic, in person, or a video session. In case of a video session, the mediator can enter the details of the meeting URL, be it Zoom link or Hangouts, or any other video communication provider. After the mediation sessions are concluded, and the parties have arrived at a resolution, the mediator can draft the settlement document by clicking on the Draft Settlement Agreement under Your Next Steps. Here the mediator has the option to either upload a document, in case the document was already drafted using a word processor, or the mediator can choose to use the CREK Online Document Editor. If the mediator chooses the online editor, there is an option where the mediator can choose from an existing template and start editing the template for faster documentation. Once the document is ready, the mediator can send the document for review to the parties. The parties will then receive an email notification regarding the draft settlement, and they can click on the provided link to accept or decline the settlement. In case one of the parties declines the settlement document sent for review, the mediator can use the private caucus to understand the reason for disagreement, and use the draft settlement agreement to make the edits and submit it for review again to the parties. This is an iterative process where the mediator can edit and send the document for review until both parties agree. After both parties agree, the mediator will have the option to publish the settlement document as the final settlement agreement, agreed by both parties. After the settlement document is published, the mediator can update the mediation outcome. The mediation outcome can be full settlement, partial settlement, or no settlement. The case manager can then close the case or move the case to arbitration, depending on the mediation outcome. In case the outcome was full settlement, the case manager closes the case. In case the mediation outcome was either partial settlement or no settlement, the mediator can move the case to arbitration by assigning an arbitrator. In case the ADR organization follows MedArb process, then the mediator will continue to arbitrate the case. Once the arbitrator starts arbitration by clicking on the Start Arbitration link, under your next steps, there will be one joint hearing session created, where the arbitrator can hear both the parties and issue an award. The arbitrator can ask the parties to share any required documents or exhibits in the joint hearing session. After the session is concluded, the arbitrator issues the final award by clicking on the Generate Arbitration Award under your next steps. After the arbitrator issues the final award, the case manager can then proceed to close the case. The case is now closed. To know more about our CREK product, please visit CREKODR.com. You can also reach us at support@CREKODR.com. Thank you.
So, as you all notice here, that we got a demonstration not just of mediation, but also of a flavor. We got a flavor of the arbitration aspect also. We can consider doing what people call as med-arb. Very frankly, arb-med-arb or arb-med are not a new phenomena for India, though nowadays people talk a lot about it, simply because in our Arbitration and Conciliation Act 1996, we already have the provision where should the arbitrator feel, he can consider taking up several conciliatory, mediatory steps to see if we can get the parties to talk to each other and resolve it. Of course, there is always the ethical issue of whether the same neutral should be wearing both the hats. And that's a risk. So I leave it to the parties. When I used to do it, I would leave it to the parties that either I continue as the arbitrator and allow you to appoint another mediator, or should I change over to wearing the hat of a mediator, and should we not settle, then you will have to appoint another arbitrator. So that's again another thing which you can work out with the parties depending on how they would feel comfortable with you as an arbitrator or as a mediator. Now, when we are looking forward to taking the step towards ODR, that is taking our ADR practice online through the several platforms, we need to be careful about a few things. I say words of caution, but these are only preparatory steps which we need to take, keeping in mind certain aspects. For example, non-suitability of ODR. We already know in ADR as it is, there are certain types of disputes which cannot or which should not be taken through the mediation route. However, there also my view is that there is no reason why you cannot try that in addition to any other mode that is mandatory, statutory, or required, considered required. For example, if you are having a criminal case, then you can allow that. I mean, you of course can't do anything about it. It does go through the criminal procedure. However, you find there also that parties do not get a closure. Just because somebody gets a punishment, it does not help the victim. And the culprit initially is then a victim of the system for life probably, or at least for several years or decades. So often mediation has been found to be deployed over there in criminal matters also, and you can read a little bit more about it through our Baba. You can look for restorative justice or reformative practice, and these keywords might get you restorative justice, might get you to some links. Now, in ODR also, I find that though all those cases which can be taken up in ADR, by the way, ADR I mean mediation rather than arbitration, because arbitration is ADA, adjudication. We are talking of alternate dispute resolution, which is not adjudication, and therefore I restrict myself to mediation for the rest of the session whenever I talk of ADR. So when you are taking mediation through the online platforms, you will notice that if you are looking into the camera, that means you are not looking at the person you are talking to who is on the screen. We are presuming today there is only that one other person on the screen. Still, you are not looking at that person if you are looking at the camera. And if you are looking at that person on the screen, the person feels you are not looking at them, because for that you need to look into the camera. So these are the nuances that we will be facing. Of course, I always look to the future where we can have holograms and we can have virtual cameras behind the screen, where wherever I look, my eyeball may go, that area's camera would come on, ignite, and I would be speaking to that very person whom I'm seeing on the screen, even if there are 10, 20 of us, like presently on Zoom seminars we often have. So that's one thing. And why I say this is because some cases they are always having a miracle working when people are shoulder to shoulder, eyeball to eyeball, and they are very much into each other's conversation. So that's where I find, especially for cases like where an apology would be required, such type of cases are always better off being done face to face. However, if we are to do them online, then we need to get this understanding in place that if he is not looking at you, you need to understand that he is probably actually looking at you rather than looking at the camera through which you might feel he is looking at you. So these are the few nuances which we need to educate the parties when we take them online and for these sensitive situations, moments. The other thing is that sometimes there is a connectivity issue, sometimes there is a bandwidth issue, and sometimes the connectivity is there, the bandwidth is there, and still there could be some technical glitches. We need to sensitize the parties about what would be happening and what might just happen and how things shall be taken care of. So a little bit of education, a little forewarning about SHIT hitting the fan and how we shall take care of that. So these are some of the educational aspects we need to get across. Then, of course, there are the platforms. We need to have an understanding of what platform we would be using, and we need a buy-in from all the stakeholders, the institution, if it is an institutional mediation, if it is person who is an expert who is going to come in, then we need to get them also on board about the platform we shall be using. But definitely we want the mediator and the parties to get a sense. Maybe there are two mediators, co-mediation is there. Then we need to get them all on an understanding about which platform we shall be using and what are the nuances of that platform. Today, we are at a nascent stage in India, so I do not readily see people having their own platforms for captive consumption, except for a few of these platforms which are already in the marketplace and who have their rules also. So should you want, you could prefer them and some of their panelists to be your mediators. So that's a possibility. However, where you are looking at a local credibility, you do want first to see the credibility of the neutral and then consider the platform. And platforms abound. There are so many of them, and platforms can be switched over from one to another. Whereas a mediator, if you know him, then you do not want, just as if you have a doctor, you do not want to change a doctor just because another one has started living closer to you. We always have a certain bit of faith and trust in our age-old relationships. So that's one issue. The other issue about the platform is that sometimes some platforms, there is some cloud over them for a moment, maybe for a few months or a year. Like, for example, even in Zoom, we had this concern where some mediators told me they have just removed everything about Zoom from all their instruments. So now we can't have a Zoom webinar and expect them to be joining in. They have preferred something else. Now, such concerns might arise for some of the other platforms from time to time. And these are things which we have to live with and understand and set in place some fallback plan. And all those fallback plans, as well as the system, putting the system in place, everything needs to be addressed in the rules of the institution which is going to be doing the mediations. So these rules do require several things to be kept in place, put in place. Take a few moments to go through them. But in addition, we also want to consider something like an ombudsman, what we call an ombudsperson, to be there as an institutional figure for every sort of dispute that you may have regarding the whole gamut of the institutional rules, the mediator, the platforms, and about the nuances of the platforms and whatever glitches and whatever transpired and whatever are the fallouts of those. All these, we need an ombudsman to look into and help parties move on in a way that they then focus on the dispute that they came with rather than be stuck on the dispute that has now arisen in the process of dealing with the dispute that they came with. So that's something which would be a good thing to have, though it's something very sophisticated. So a lot of thought through will be required to get things in place about that. Now, what are the rules that we need to have in place? Firstly, I have been party to drafting about at least half a dozen drafts I have done about mediation and mediation institutes. And I would be really finding it tiring to now revisit all of them to add the online aspect for doing those mediations through those institutions. So yes, it would be a good thing to have an omnibus law coming into place set in by the legislature, that all mediations and all mediation institutes and all mediators doing mediation offline will be deemed to be fine to do them online, and as long as all parties are informed well in advance and their consent is taken in advance, it would be fine to conclude the whole of the dispute mediation online. And of course, we will be having, once you do online, I look at it things two ways. One is a little hybrid process where you start off and you end off in the real world, but you mediate for the most of the part online. And then the other one where you do from end to end online. When you are in the second style, end to end, then you do require the signing of the documents, for which you have one Indian company, I think Legality, which does those online documentation. And then you have DocuSign and a few others who are into online documentation, signing and all that. So you have those digital signatures coming in. And in fact, I think all in India, all the directors are required to have a digital signature. So maybe we could use them also to sign the documents, where everybody could be asked to get one for themselves. Maybe the platform can account for that, factor that into their fees, where they would also get a bulk sign up for all these digital signatures and then list them out to the parties as they come in to select their mediation to be done through their institutions. So that's something which is there. Then one very crucial thing that you need to be careful of is that in a mediation, we are talking of confidentiality. Therefore, what we see happening is that I know my other side, who is the person with whom I have a dispute, but I do not know who the mediators are, and therefore, when I go for selection of mediators, then I look at their profiles, I make some inquiries. Usually, it's my lawyer who handholds me through this process, saying that yes, I know this person or no, and we move on towards that. However, in online, you also have the technology coming in. Once you have the technology, then to manage that technology, you have the admin. So rules may, I think they will, require to factor in the presence of this fourth party, the technology, the platform, and with that would be coming in the admin, who will be sort of helping out with the mail, emails and messages and the system itself as to how well it is running and keep it running well. So that's one other aspect. Then, of course, considering that mediation is a party-centric process, it is always the parties who choose. So some rules may have it as a default clause that should parties or the system require, or should the referencing authority, like maybe the court, the high court or the district court, so require, then parties shall be going by default, they would be going online. And whether or not they could have an opt-out is another thing which will need to be considered. Because if the courts are saying so, then I don't know to what extent this opt-out would be feasible, and whether it would at all be a good idea to consider giving that option to the parties. But yes, opt-in always is to the party's choice, especially where one party is from out of town, then they would prefer to do things online. And even if they don't agree, then at least the party who agrees, they can do the private sessions online and then elongate the process a bit more to afford the offline to be held for the joint sessions. However, it always works best for everybody to speed up the process, and therefore online is, in my view, the best way forward. Now, when we are talking of doing things online, then of course what traditionally we are taught about body language and words and tonality and all that, to an extent goes for a toss. You need to therefore train the parties a bit more about their presence online. And I remember a couple of months back when we started with the lockdown in India, there was a Supreme Court two-liner judgment that the matter was called out online, and one lawyer was sitting in his banyan. So the matter is now adjourned by a few weeks. So you do need to be a little bit careful, cautious about setting things up online. If it's like, presently, if you're just looking at my screen, then it may not matter. You may not even know when I removed my glasses and put them back on. But you do need to take care of these things when you are online, about your presence and your demeanor and your behavior. Then we also need to understand which part of mediation, if at all that is something which we are looking at, we need to see which part of the mediation we want to do offline, even if we have an online understanding. And to give you just one example, which I mentioned earlier also, that wherever an apology is required, it is something which you don't force it out of a party, but where the mediator feels that today I would like to see if I can get a closure for the parties, or at least get them closer to each other, then he may or she may schedule an offline meeting and talk about how we can proceed with the apology, of course, with the prior consent of the one who is wanting to apologize. So these are some of the options which we have, and therefore we must be mindful that which would be the most efficacious option for which leg of the dispute resolution process. So that's another thing we need to be careful about. Now, when we are talking of the platforms, you do want to see which are the available platforms and which are the platforms which the parties are comfortable with, and which are the platforms that would be available throughout to all the parties and the mediator, and the institution is fine with that platform being used. So there are several permutations, combinations. But to give you an example, that parties may want to do things, of course, face to face, and therefore may prefer video conference. But if one person is in a region where the bandwidth is low or the connectivity is unstable, then the audio would be preferred mode. One good thing about doing mediation, arbitration online, is that we are not so concerned about everybody being present in front of everybody. We are also certainly not concerned about creating, maintaining records. Therefore, the institution really plays a very minuscule role where we do mediations, as compared to arbitration, where the institution is really like holding the lagam of taking the parties' calendars in hand and getting them to agree and do it sooner. And the mediation process does not require so much of a role from the institutions. And therefore, in mediation, we would not be so concerned about the processes, but about the platforms that we use. And the choices are much wider as compared to if people are doing arbitration. So availability of platform is something which parties and mediators, as well as maybe even the institution, may want to look at closely for what would be available all of the time, and how to set the best ones in place, along with setting in place the fallback plans, the fallback platforms. And you do need the availability of mediators, a wide choice of them, some elderly, some lawyers, some non-lawyers, some young people, some specialize in certain fields, probably the field from which the dispute arises, some not at all trained, because there is a great charm in having non-specialized mediators more than having specialized one. So all that option must be there for the parties to choose. But one thing has to be given: each and every of the several types of mediators must be thoroughly trained, not only in the mediation process, but also in doing things online, and especially doing it on the chosen platform, the platform chosen by the parties. Certainly these things must be there. And I'll tell you, there is really no gainsay in saying I have done 40 hours and therefore I'm qualified. I'll say it online that that's not so. And even several judges have mentioned this in some conferences, that 40 line is not your qualification. 40 hours is just your statement that yes, I stand committed to move and proceed and progress on the path of being a mediator. So 40 hours is just like your marital vow, then you have got your whole life ahead of you. So 40 hours is your first pot of call, your starting point. And then you need to do several advanced courses, several specialized courses, several peripheral courses, and definitely you need to do your online mediation courses. There are some very good courses available. And even in those cases, I may tell you that I also, after having taken 15 years of training in about 30, 40 workshops in mediation and equal amount outside the mediation field, I also still require to every few months, at least a certain number of hours I require to put in as my time in getting myself trained. And this extends even to online mediation. The organization that certifies me to be an online mediator, ODR mediator, requires me to put in a certain number of hours every now and then to ensure that within a year I complete a given number of hours to be continued to be qualified to hold that certificate of online mediator. So that's another thing. And I may mention that mediate.com is one organization. In case anybody may have any question, you can consider that, mediate.com. And then there is Bruce Edwards. They do online courses, and mediate.com also does courses for training people to be online mediators. In addition, I of course also am in the process of announcing my course in Mumbai, but of course that will be for a very restrictive audience of just 6 people, and that will be for a 40-hour course separately and for an online mediators training separately. So these are the requirements to be an online mediator that every person who wants to be a mediator will have to be careful about. Then you need to have congenial rules which are very clear and flexible and self-lubricating. By self-lubricating, I mean, if you recollect, I mentioned some time back, the ombudsman. The rules themselves should provide for whatever disputes that might arise. Firstly, it must take care that it never arise by making things so simple, fluid and clear. But even then, should a dispute arise, then the rules should provide for getting them resolved there and then in a very short span of time, so that then parties can continue with their focus on the dispute that they came in with in the mediation before the mediator. And now, secondly, for the platform, you need to be aware that all platforms are not equally priced, and therefore you may want to consider which of the platforms you want to go for. There have been some contracts which have got the multi-tiered clause, which says that in the event of negotiation failing, they shall go for mediation, and should that fail, which usually always, both of which always fail, then they shall go for arbitration as per the rules of ICC or LCIA or some such international arbitration organization. Now, those arbitral tribunals cost a lot of money. And in one case, I do remember where the claim was just 30 lakh. I pointed out to that time I was practicing as a counsel, but the client was from the time when I used to be a lawyer, practicing in a law firm for a couple of years. So at that time he asked me, and I told him that your case is just for 17 lakh rupees, and that's the amount, 15 or 14 lakhs rupees is what you will have to spend just to get things moving. And then should you fail, then you will have to, should you lose, then you will end up paying the other side's fees also. So you're going to end up spending double. That's what the amount you are putting at stake for just half of that amount which you would get back should you win. But even if you win, your expenses are already there at around 10 lakh rupees minimum. Therefore, you need to be careful about even the platform that you choose. Mediators also sometimes do have a branded or non-branded platform that they are subscribing to. But then all those get factored into the cost of the mediation, and therefore those are the things you need to be careful about. The cost of the platform that you are using and the time that the platform provides, because usually they provide a month or so, expecting mediations to be over in just a few sittings as it is. But we Indians have this habit of prolonging things, so we never do things overnight. So cost overruns will be there even using the platform, which might not be available for just a long period that you want it to be, and therefore you have to have recurring costs of renewing that period. So that's another thing. Now, if you have all in one roof, a one-stop shop set of rules which provides for everything, ADR and ADA, then the benefit is that parties don't need to go everywhere, here, there. They can just be under one organization, institution, and that institution will lead them through the process and seamlessly take them from mediation to arbitration should the mediation fail. However, that may not be such a good thing, because people sometimes have a perception that if you are going to expect a second round of arbitration and therefore a second round of funds coming in, then probably you might not be so well focused or well geared to do things the mediation way, and therefore some people may not prefer such institutions. And on the other hand, many people would prefer such an institution which provides everything under one roof. So that's another thing you need to be careful about, and you need to have your contract accordingly, where you may want to keep it robust. You may want to suggest to different organizations that will try for mediation first under this organization and then for arbitration under some other organization, even though that other organization may also be having mediation services. So these are some things you may want to consider when you are having your contract set in place. And then is the issue of artificial intelligence, AI. Once you have that, then as I said, that mediation is not just, ODR is not just mediating online, it's a lot of plus plus. And here is where artificial intelligence comes in. Sometimes parties would like to have an objective criteria, would like to have some private evaluation done about what they would like to do, and that's where AI comes in. I remember, I don't know whether the platform is still available, the services, but it was Square Trade or some such name, squaretrade.com or Settle, Smart Settle, one of these two names. And they had a very nice algorithm where should you finish with your mediation and feel that if someone feels that maybe we could get some more value out of our settlement, maybe we can get a better settlement than what we already have, then you may go to one of those two, I forget which one, you could go to one of those two algorithms and put in the values for the different items that you have and different assets that are on the table, and the algorithm would agree. I mean, it's an agreement that you have over there with that platform, that only if both of you are having a shift from your original agreement, then and then only will we, to the extent that you have agreed on the platform through your feedback, the question answers that we privately ask each party, that we would be revealing to you what you have both agreed to on those agreed points. So maybe you want to use some platform as a fallback plan or as an additional platform that you may factor in, or you may agree to later on to consider to see whether you can get a better settlement than you have already got in the mediation that you have gone through. So that's AI for you to an extent. Then there are other benefits also. But moving on, essentially with all things in place, it's the confidence of the party. You may be having a doctor living in your own building, maybe two, I have three. But still you may be going 10 kilometers away to a doctor whom you have been going to, accompanied by your grandmother and then by your mother and father. So confidence, faith, trust is what ultimately will carry things. And that's where the organizations will have to put in place robust rules to ensure that the trust builds up in the parties as we move along and the word of mouth spreads, so that more and more people have this particular platform or this particular organization, institution, and their rules in mind for considering, for resolving their disputes. Now, friends, this is the crux of doing things online to a certain extent. However, you will require to consider even the legislation that is likely to come down the line. I am having in front of me Press Information Bureau notification, which has been issued just a day or so back, today or yesterday maybe, saying that the government, the legislature, and the executive, and the judiciary are all working together, closely looking at how to afford mediation online, how to enable ODR for the Indian masses. So we can very soon expect better and better news down the line. However, it's essential that we also, as individuals who are in the field, maybe as mediators, maybe as institution heads, maybe as some other stakeholder, it's essential that we also keep our ears to the ground and see how the developments proceed, and also make our own efforts to get these developments some speed. Thank you very much. That was my talk on ODR, which I hope summed up even the first part